Thank you, counsel. Justice Thomas, anything further? Justice Alito?
If we thought that this statute engages in viewpoint discrimination, does that have a bearing on whether we should decide whether it satisfies the applicable constitutional standard or remand the case?
I think it makes it even clearer why it fails strict scrutiny, but I think even as a content-based restriction, it pretty clearly fails strict scrutiny.
Thank you.
Justice Sotomayor?
We keep going back to the question of the studies and what's the strongest list tick off. The thing that gives me pause in not applying strict scrutiny or in applying it is that none of the studies say that talk therapy is harmful. Is that correct? And Colorado.
For this type, for talk therapy by a licensed therapist to minors, they don't have any studies that say that that is either harmful or ineffective. And indeed, they often concede that they don't have that. The 2009 APA report expressly acknowledges at pages JA 221 and 256, expressly acknowledges that they don't have evidence of that. And if you look at the Glasgow Declaration, which is after 2009, she too doesn't cite anything. If you look at the studies that she cites in her declaration, all of them are conflating either aversive and non-aversive or licensed and non-licensed or minors or adults. They just don't have anything. And this comes up to the court after a PI hearing. And if the strict scrutiny applies, they bore the burden and they just don't have anything.
Thank you.
Justice Kagan?
Mr. Mupon, you have an evocative example in your brief which I want to pick up on, which is, let's say there's a school of psychotherapists that think that the best way to deal with suicidal patients is to go dare them to commit suicide. And you basically say, yes, strict scrutiny applies, but don't worry, it could be satisfied in a case like that. And I just want you to run through that and tell me why you think strict scrutiny applies and why you're confident that it could come out the way you think.
So I'll say a couple things about that, Your Honor. So first, we think strict scrutiny applies if the law was structured the way this law is.
Yeah, that's what I'm
saying. So if it was a
assuming.
categorical prior restraint. So if it was a categorical prior restraint, we think strict scrutiny applies because it's content-based, it's not incidental to any conduct, and there isn't any history or tradition of imposing that sort of prior restraint. So we think you're in strict scrutiny. As to why we think you could satisfy strict scrutiny, because that type of speech has utterly no redeeming value. It might be the type of speech where you don't even need a study because it's so obviously harmful.
Yeah.
There's no real benefit.
Is that the right analysis? I mean, when I think about Brown, which I found one of the most difficult cases that I've ever encountered on this court, you know, we really did insist, no, you need to have studies. You need to have a kind of scientific showing of causation rather than rely on your intuitions that, of course, this causes harm. And why wouldn't that be true in a case like this? And if it's not true, if you're right, you know, are we basically diluting our strict scrutiny standard in a way that will come back to haunt us elsewhere?
So I guess what I would say is this, Your Honor. If you were not confident in your judgment, then you probably should require studies. But if you were confident, and I think on a case like that you probably should be, it would be enough. But what I absolutely agree with is that you should not dilute strict scrutiny. It's important that strict scrutiny retain its rigor where it applies, but it's also important, as this court held in NIFLA, not to create additional exceptions to the general rule that content-based restrictions are subject to strict scrutiny. And if you take a step back, the other side just doesn't have any doctrinal or historical basis for getting this out of strict scrutiny. They can't say it's conduct because there is no conduct. They can't say it's history because there is no relevant history. All of their arguments would blow a massive hole in this court's case law, emphasizing that its treatment is inconsistent with Holder and Cohen, which says that the fact that you could point to some other law that generally regulates conduct isn't enough if the particular speech is what's triggering that content-based restriction.
Thank you.
Justice Gorsuch?
Justice Kagan's hypothetical, could you point to a long history against assisting suicides?
You could, but whether there's a long history of speech related to that, especially in a context where the speech, where if suicide wasn't unlawful.
There have been convictions for counseling people to commit suicide and encouraging them to do so, and providing and maybe providing a substantial step toward. Those have been all over the books for hundreds of years.
It's true. It's a little trickier because I don't want to. I agree with you that that's a potential additional argument the state could make. I wouldn't want to leap to that because it would turn on things like
speech versus conduct.
Is suicide prohibited? So it's unlawful conduct.
No, it's not. But assisting is. Most states.
Right, but so then it's a little bit harder to say it's speech incidental to regulated conduct. And even if suicide is illegal, the degree of connection, it's, the incitement question under cases like Brandon.
Yeah, it essentially becomes an incitement.
Exactly.
And that is illegal.
Yeah, and I did want to make one other point to Justice Kagan, which is, I think another way of thinking about this, her question was about ex ante categorical prior restraint, but often this sort of speech, I think,
always after the
quite
fact.
easy as an after the fact malpractice.
Yeah.
But I would like to say a couple of things about malpractice, because I think malpractice presents very different types of questions than this sort of law.
Because it's not prior restraint.
Yes, for three reasons. So the first reason is often malpractice is incidental to conduct. It's speech that's restricted, tied to some conduct. The second is, as Your Honor just noted, this is a prior restraint, and this court has recognized in a lot of cases like Florida Star and NTU and Madigan that for First Amendment purposes, it's very important, the difference between letting someone speak and then adjudicating individually that speech after the fact rather than categorically banning it ex ante. And the third and related point is, as a matter of history and tradition, we have a long history and tradition in this country of malpractice. Now, how that history and tradition cashes out for this type of speech is a tougher question, to be candid. But what is not a tough question is there is no history and tradition for this sort of prior restraint.
Thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson?
Can I ask you about licensing? You talked a lot about malpractice, but don't states tend to tie licensing requirements to the standard of care? And so if we had a situation like this in which a state licensing board disciplined a doctor for a speech-based practice outside of the standard of care, would that doctor have a First Amendment defense?
So there is a long history and tradition in this country of licensing, and even licensing for people who engage in speech. What there isn't a long history and tradition of is, as a condition of that license, imposing a prior restraint on the types of speech they engage in. And we know from NIFLA that the mere fact that there's a license isn't enough to obviate First Amendment review. Obviously, the whole point of NIFLA, it was regulating.
But NIFLA was a notice scenario, right? It wasn't
for a licensed clinic.
No, I understand, but it wasn't connected to the provision of services to particular people. That was part of the analysis. And so I guess what I'm saying is a doctor who's providing services pursuant to a state license, I'm just trying to understand how the First Amendment protects that doctor from providing therapy that is outside the standard of care.
Well, because in NIFLA itself, the court made clear that part of the reason it was rejecting a professional speech exception is because it was very worried about the risks of the state interfering with the doctor-patient discourse. And it gave us an example how in certain authoritarian governments, they do things like tell doctors you can't tell patients about birth control.
Yeah.
Those people are all licensed. And so if there was some sort of argument that because you're licensed, all of a sudden the state can tell you what to say and what not to say to your patients, those very harms, the precise harms that NIFLA pointed to, could happen.
Can I ask you just one final question, just sort of from a very broad perspective? I'm wondering why this regulation at issue here isn't really just the functional equivalent of scrimetti. I mean, I realize that there were two different constitutional provisions at issue, but the regulations work in basically the same way, and the question of scrutiny applies in both contexts. So it just seems odd to me that we might have a different result here.
Well, scrimetti was a law that regulated on the basis of age and medical treatment.
No, but here's what I mean, right? In scrimetti, we had a state that wanted to prohibit certain medical treatment, gender-affirming care, being given to minors in the form of medication. And we said that was okay, and I understand there are particulars with respect to how the arguments, the constitutional arguments worked, but the state can prohibit that. Here we have a state that wants to prohibit gender-related medical treatment in the form of talk therapy, but we now have the First Amendment that is inhibiting the state's ability to do that. And I'm just, from a very, very broad perspective, concerned about making sure that we have equivalence with respect to these things?
Well, from a very broad perspective, there shouldn't be equivalence because obviously we have a First Amendment. So when you have treatment
talk therapy, the speech is what is at the core for you. It's not necessarily the state's interest in protecting minors from what it believes to be certain harmful treatments.
Just like in Holder, the state had a very compelling interest in stopping material support of terrorism.
Right.
But when you stop terrorism through speech versus from conduct, the analysis is
Got it. All right. Thank you.
Thank you, counsel. Ms. Stevenson?
Mr. Chief Justice, and may it please the Court. Throughout its history, this Court has recognized that state power is at its apex when it regulates to ensure safety in the healthcare professions. Colorado's law lies at the bullseye center of this protection because it prohibits licensed professionals from performing one specific treatment because that treatment does not work and carries great risk of harm. No court has ever held that a law like this implicates the First Amendment, and for good reason. First, the law applies only to treatments. That is, only when a licensed professional is delivering clinical care to an individual patient. In that setting, providers have a duty to act in their patient's best interest and according to their professional standards. The First Amendment affords no exception. Second, because this law governs only treatments, it does not interfere with any First Amendment interest. It does not stop a professional from expressing any viewpoint about that treatment to their patient or to anyone else. And because Colorado's law regulates treatments only, and because it enforces the professional standard of care, the law falls squarely into the reasonable regulation of professional conduct that does not trigger First Amendment scrutiny. Petitioner's argument, on the other hand, cannot be reconciled with history, precedent, or common sense. A state cannot lose its power to regulate the very professionals that it licenses just because they are using words. A healthcare provider cannot be free to violate the standard of care just because they are using words. And a state cannot be required to let its vulnerable young people waste their time and money on an ineffective, harmful treatment just because that treatment is delivered through words. Petitioner asked you to enjoin a bipartisan law passed by 25 different states, but she did not put one single piece of evidence into the record. Not a single expert, not a single study, not a single mental health professional willing to endorse conversion therapy. And there is a mountain of evidence to the contrary. On this record, we request that you affirm the denial of preliminary injunction. I welcome your questions.
If petitioner were a non-therapist, would this be protected speech?
So I wanted to mention our law covers physicians as well. They are also subject to the conversion therapy ban. But if you're talking about a non-professional, I think it would. Our argument is premised on the notion that there is a special relationship between a healthcare provider and a patient, where that patient is in a position of vulnerability and dependency on the healthcare provider, and the healthcare provider owes fiduciary duties to act in that patient's best interest only.
In Colorado, are there only healthcare providers who provide this sort of service?
No, the law accepts, I don't know factually if there are, but the law exempts religious ministers and ministries from this, and there is also a group of people called life coaches who could perform this therapy.
So what exactly transforms speech in that context to speech that is protected in that context to speech that is not in the therapist context?
It is the relationship between a healthcare provider and the patient that establishes this special context. And again, if you go to a life coach or you go to someone else, they're not licensed by the state. You're not expecting them to be complying with standards of care. You have a different expectation. When you're going to see a licensed healthcare professional who owes you fiduciary duties, your expectations are different. You're expecting information that is complying with the standard of care and not expecting the practitioner to just be exercising their right to say whatever they want to say. And that's just materially different, and it's always been treated so.
So what if someone who happened to be devoutly religious and actually relied more on the minister than the therapist? It would seem that that person would be equally dangerous.
Well, I think that would be a personal choice that they were making to rely on their religious minister. It wouldn't be a representation from the state that this is a licensed professional who we are holding to a certain standard of care. And so the expectation, at least vis-a-vis the state license, would matter a lot. And in addition, the religious minister, just as a legal matter, doesn't owe fiduciary duties in the same way that a healthcare practitioner does.
Counsel, you said, just because they're using words. But our cases separate those out. Holder, NIFLA, in other words, just because they're engaged in conduct doesn't mean that their words aren't protected.
So, Chief Justice, our case is absolutely premised on the notion that communications that are happening in the very specific context of treatment, which I will call a licensed professional delivering clinical care to an individual patient, where they are subject to fiduciary duties and subject to malpractice, that is fundamentally different, a fundamentally different regulation than a regulation of people out in the world going about their business, like at issue in Holder, where you have generally applicable statutes that apply to everyone. This is just a fundamentally different relationship. It has always been treated like that. In NIFLA, the court talked about the fact that longstanding torts for malpractice did not implicate heightened First Amendment scrutiny, and I think that analysis is exactly the same here. Malpractice, you're dealing with that same individualized relationship, and this is the exact same context.
Ms. Stevenson, I want to ask you what Justice Kagan called the mirror image question, and Mr. Mupon and Judge Hartz's example about homosexuality in the 1970s was professionally considered to be a mental health disorder. What if a state back then might have passed a law prohibiting talk therapy that affirmed homosexuality? Would that be subject to rational basis review on your theory?
So, Your Honor, what our theory depends on is that there is a treatment being provided that's being regulated, and that the regulation is consistent with the standard of care.
Let's check both of those boxes in our hypothetical.
Then yes, and I want to return to Justice Jackson's point, because
yes,
they could regulate.
The state could forbid a regulated licensed professional from affirming homosexuality if that were consistent with the then prevailing standard of care.
That's right.
And so likewise, if the prevailing standard of care were to change or to solidify that this sort of talk therapy is beneficial to minors, or at least not harmful to minors, then a state could pass a mirror image statute to Colorado's that prohibits any attempt to affirm changes of gender identity or sexual orientation, and that would be subject to mere rational basis review on your theory.
That's right, Your Honor. And just to illustrate, it's not the fact that there are words involved doesn't make it different. So states, like we recognized in Scarametti, have the power to regulate even in the face of medical uncertainty. The laws or the standard of care could change there, and the legislature can act to change that. And
so even in cases where medical uncertainty exists, you think that the state could pass such a law prohibiting ex ante speech that would affirm gender identity changes or sexual orientation changes or homosexuality?
I don't think you have to reach that question in this case, because
I'm asking about the logic of your argument. I think you just said states can regulate even in the absence of medical consensus in this fashion. Is that right?
Where there are no words involved and no First Amendment issue raised. And
I'm asking, we're talking about speech and we're talking about therapy, talk therapy. That's what I want to get at. And I think you're saying that if there's medical consensus, states surely could pass mirror image laws. And I think you're saying, but I want to make sure, that even in cases where there's medical uncertainty, the state could so regulate.
You could reach a holding in this case that said, yes, treatment is treatment, and this can be, it doesn't matter whether it's consistent with the standard of care or not. We would urge you to reach a narrower holding in this case.
I understand that, but I'm asking you to answer my question. Could a state, when there's medical uncertainty, and we normally provide, this court has many times said, when there's medical uncertainty, we defer to state judgments. And I think you're saying that yes, I think the logic of your position has to be yes, and I'll let you go as soon as you give me an answer up or down on the state of medical uncertainty and whether they could pass mirror image laws.
I think it's less clear that that fits into the historical tradition identified in NIFLA that calls specifically out malpractice, which is an enforcement of the standard of care. And while that question could come up in another day here, where we meet the standard of care, we don't think
Counsel,
we need to reach it.
It's pretty important, though, to think about how this would apply to cases down the road. So let me describe medical uncertainty as competing medical views. and let's say that you have some medical experts that think gender-affirming care is dangerous to children, and some that say that this kind of conversion talk therapy is dangerous. Can a state pick a side? So it's not, I want to be very clear, it's not that the medical community says, we just don't know. It's that there are competing strands. And some states, like say Tennessee, which was the state at issue in Scrimeti, pick one side, Colorado picks another side. Your position is that rational basis applies?
Our position in this case is that the standard of care is important. It's important because that's been the historical
But like Justice
tradition.
Gorsuch said, just answer that question.
No, our view is that would not be the right rule here. One, because that's not consistent with the history and tradition identified in NIFLA. And two, because the reason why that history is important and the reason why the standard of care is important is because it's a confirmation that the state is not actually trying to shut down.
Okay, I'm not understanding why
viewpoints.
the standard of care. Tell me. I mean, maybe I'm not following you. Are you saying that the standard of care? Why do you think the standard of care question isn't relevant there? Because wouldn't that be a situation in which Colorado is essentially saying that the standard of care, that we're essentially looking at expert evidence and saying that we think this is what's appropriate, that we shouldn't have this kind of talk therapy, and Tennessee's choosing a different one as a matter of its state law? Or am I not understanding that correctly?
What I'm saying is where there is a First Amendment issue raised and the state can show we're regulating a treatment and we're regulating consistent with the standard of care, there is a confirmation, a security that the court can have that there is no other motive going on to suppress viewpoints or expression. And that's what's consistent with.
So Colorado's law would trigger rational basis, but Tennessee's hypothetical law would be strict scrutiny.
If it were against the standard of care.
So there's no mirror image.
Counsel, can you define
Justice Kagan?
standard of care to help us? Is the standard of care a medical consensus about what should happen in this situation?
It's the same standard of care that would apply in a malpractice case. Yes, that is how.
So it's not a
defines.
situation in which you have competing doctors and there isn't a consensus on what is supposed to happen.
Correct.
No,
So
but I think you could have that. In my hypothetical, I'm saying that there might be a dispute in the medical community, is my hypothetical, where you have some experts saying that this should be the standard of care and others saying something different. That was the hypothetical.
Well, the question would be, is the regulation enforcing the existing standard of care? And you're describing a situation where it sounds like there would be many viable options under a standard of care?
Yeah.
Right. And so in that instance, I think that would raise more significant questions if there were actual multiple procedures, treatments available that all met the standard of care. And again, this is just a question that would be resolved exactly the same as it would be in a malpractice case where you could have, competing experts as well, and we'll decide, is this thing inside or outside the standard of care? If petitioner could put on an expert to show conversion therapy is inside the standard of care, then I think we wouldn't be here. That would be a different standard to apply to our law.
I have a question about how you're distinguishing Holder. It was a generalized law against providing material support to terrorists, but you seem to be suggesting that if there was a Bar Association rule that said it's a breach of your duty as a lawyer if you tell terrorists how they can break the law, that would be subject to rational basis review.
So I think that, again, the critical aspect of the relationship is that there is a duty between the professional and the receiver of the professional services. And it sounds like in the law that you're describing, Justice Sotomayor, there would be the law is passed for some other interest than to protect the client in that case. And I think that's materially different. When we're talking about a special relationship where the client is depending on the expertise and training of the lawyer.
But I'm just not sure why that makes a difference. If we're talking about the speech aspects of it, why that becomes any less protected?
It's because that's how we've always treated speech between, especially in the healthcare context, between providers and patients. This has been an area that has been heavily regulated from the beginning of our country, and no one has ever suggested that a doctor has a First Amendment defense to say the wrong advice to their patient. And just to give an example on this speech conduct distinction, if I went to my doctor and had high cholesterol, she could tell me a number of things. She could say, come back next year. She could say, eat less red meat. She could say, I'm going to prescribe you a statin. Or she could say, you need an arterial stent. And whichever way she violated the standard of care and making a wrong judgment there could be equally harmful to me. And so I don't see how you can parse out whether there is conduct involved in terms of when you're talking about professional services delivered in a fiduciary relationship where the client or the patient is expecting accurate information and information delivered to benefit their health.
I don't really see a difference between the argument that you're making now and the argument that I thought we rejected in NIFLA, that professional speech is a special category that's outside normal First Amendment scrutiny. But let me put that aside and ask about your interpretation of the statute at this stage in the litigation. And let me give you this example. Suppose an adolescent male comes to a licensed therapist and says he's attracted to other males but feels uneasy and guilty about those feelings, and he wants to end or lessen them and asks for the therapist's help in doing so. Under your interpretation of the statute, is that banned?
So, Your Honor, our interpretation of the statute turns entirely on whether the purpose of the therapy is to change the person's sexual orientation or gender identity. If that
what is the answer to my question? Is that banned or is it not banned?
If the therapist told him or he asked, can you help me become straight, the answer would be it would be banned. If it was, can you help me cope with my feelings as to how I am and how I want to live my life, that's permitted. And all of that comes
why doesn't the situation that I've just described fall squarely within the terms of the statute, which says that conversion therapy includes, quote, efforts to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex.
If those things are undertaken with the purpose of changing orientation or identity, then they violate the statute.
That's not what your statute says.
This is the way we've interpreted the statute from the beginning of this case. It's the way both of the lower courts interpreted the statute. It's the way every state that has this statute interprets it. And the reason why is because the harms from conversion therapy come from when you tell a young person, you can change this innate thing about yourself. And they try and they try and they fail and then they have shame and they're miserable and then it ruins their relationships with their family or...
Well, I understand.
This is where the harm comes from.
I understand all of those arguments. What I don't understand is how you can square your interpretation with the plain meaning of the statute. Are you suggesting that everything beginning with the word including is irrelevant? You just want all of that deleted from the statute?
No, it's illustrative. And so, for example, one of the ways that people try to engage in conversion therapy would be by saying, look, you need to start dressing like a boy, and then that will make you change your gender identity. That's a way you could go about that. But if the minor wants to start dressing like a boy to match his gender identity, not because he thinks it's going to change.
That's just not the way language works. Suppose that there's a rule that says you may not bring any dangerous animals in the park, including pit bulls. Doesn't that definitively provide you can't bring a pit bull into the park?
Yes, because a pit bull is a subsidiary of a dangerous animal, but I don't think you can read an including to contradict the anchor term. So here, conversion therapy is an effort to change orientation or identity. If you read it to not mean that, then you've ruined that part of the statute.
All right,
I'm
sorry, go ahead.
I was just going to say I can't say I like meat, including tomatoes and celery. That doesn't make any sense, and that's how we read the statute. And again, have been consistently read this statute that way from the beginning of this case in every pleading that we filed.
If you recall the example that I gave you, I'll give it to you again because I want to contrast it with another situation. So in the first situation, an adolescent male comes to a licensed therapist and says he's attracted to other males, but he feels uneasy and guilty about those feelings. he wants to end or lessen them, and he asks for the therapist's help in doing so. The other situation is a similar adolescent male comes to a licensed therapist, says he's attracted to other males, feels uneasy and guilty about those feelings, and he wants the therapist's help so he will feel comfortable as a gay young man. It seems to me your statute dictates opposite results in those two situations based on the viewpoint expressed. One viewpoint is the viewpoint that a minor should be able to obtain talk therapy to overcome same-sex attraction if that's what he or she wants, and the other is the viewpoint that the minor should not be able to obtain talk therapy to overcome same-sex attraction, even if that is what he or she wants. Looks like blatant viewpoint discrimination.
As I heard your examples, I think they would both be permissible because it didn't sound like in either case the goal was to actually change sexual orientation. And again, that's the touchstone because that's where the harms come from. And if there is no goal being reached...
I guess I had the same kind of question that Justice Alito had. I mean, if we assume, for example, and this is a big assumption on your part, but just assume that we're in normal free speech land rather than in this kind of doctor land. And if a doctor says, I know you identify as gay and I'm going to help you accept that, and another doctor says, I know you identify as gay and I'm going to help you to change that, and one of those is permissible and the other is not, that seems like viewpoint discrimination in the way we would normally understand viewpoint discrimination.
I don't disagree with that, Justice Kagan, and that's why medical treatment has to be treated differently. Because anytime you exclude one harmful practice, you are by definition saying these things are allowed because they are not harmful, and these things are excluded because they are harmful. That's the driving force behind regulating the particular practice.
Let me ask you about the standing argument. There's a statute on the books, and if it prohibits what the petitioner wants to do, why doesn't she have standing? Why is it an answer, well, we haven't prosecuted her or anybody else under this statute?
I think it would if she said that she wanted to do something that violated the statute. And I think there's just been an ambiguity that has persisted in this case. What I can say is if she does not want to engage in a therapy for the purpose of changing a minor's sexual orientation or gender identity, then she is not violating the statute.
Well, both the district court, which ruled for you, found standing, and the 10th Circuit, which ruled for you, found standing. And you didn't cross-appeal on those, and not that you had to, it's standing. You didn't even put a Roman numeral in your brief on it, or even a subsection. It's footnote 18 on page 23. That doesn't exactly suggest that you have great confidence in that argument, does it?
Well, we recognize we lost it twice. And again, it is the petitioner's burden, and it has been a persistent issue in the case, I think, in defining exactly what it is she wants to do. And to come back to this conduct point.
But if she does, consistent with a patient's, I'm reading the verified complaint, if I understand that to mean, paragraphs 86, 87, that she wishes to help clients who voluntarily come and with the desire to change their behaviors, expressions, attractions, and identity, then that would give her standing, wouldn't it?
Identity, yes.
Only identity.
The others not.
The others not because of your peculiar reading of the statute, but identity would. That would give her standing.
The change in sexual orientation or identity is the key to...
And that would give her standing?
That would.
Okay.
Because you're not disavowing that.
No.
Okay. So that settles the standing question.
Thank you, Counsel. Justice Thomas, anything further?
You rely on the history of regulating the medical profession quite a bit. What's the history of regulating therapists? When did that begin?
Right. So I would say mental health and healthcare delivered through words both were in full force at the founding of this country. At the time, that was done by people you might call physicians, and all of their practice was pretty much carried out through words and giving advice. As time went on and specialties developed further, and the mental health profession sort of came into existence, those same standards applied and governed psychologists and therapists. And then I would say the licensing of counselors as other professionals in the mental health field was sort of the second half of the 1900s.
With respect to this type of regulation that is a prior restraint on speech, what was the first example of that?
So, Justice Thomas, I want to push back on the notion that this is a prior restraint on speech. There's no enforcement of this law unless somebody files a complaint with petitioner's licensing board and she has an adjudicatory hearing and opportunity for judicial review and all those things. So it's like many other statutes in that way. It simply calls out a specific practice that violates the standard of care. And those types of statutes have been around for a very long time. They were in the late 1800s. Those types of statutes governed medical professionals and then have been added over time as the mental health profession has developed and govern mental health professionals in every state.
Justice Alito?
Your argument depends very heavily on the standard of care, which I take it is defined by a medical consensus. Is that correct?
That's correct.
Have there been occasions, I mean, the medical consensus is usually very reasonable and it's very important, but have there been times when the medical consensus has been politicized, has been taken over by ideology?
We have no facts about that in this case, but I wouldn't disagree that that's possible. And I think it's a really...
Isn't it a fact that it's happened in the past?
I think
3 generations of idiots are enough?
I think that's certainly a concern, and if there were evidence of that in the record as to whether or not there were a standard of care that wasn't really based on patient safety, that would be highly relevant evidence.
Well, isn't that a reason to apply First Amendment scrutiny when what is being regulated is pure speech and not just saying a standard of care or medical consensus? That's the end of the day. Rational basis review, anything goes.
No, Your Honor, because again, when we're talking about words used to deliver medical treatment, those issues are the same whether you're talking about words being used or whether you're talking about medical practices that don't involve words. Those issues are the exact same. And there is nothing about this statute, for example, that stops anyone from sharing any opinion about conversion therapy or about how the consensus on that was reached. And again, in this case, there is just no evidence of any motive by either the Colorado legislature or any medical association to reach this conclusion on anything based on anything other than protection of minors and a decades-long record of research.
Was there a time when many medical professionals thought that certain people should not be permitted to procreate because they had low IQs?
I don't know that, but I will accept the premise.
I mean, was there a time when there were many medical professionals who thought that every child born with Down syndrome should be immediately put in an institution?
I don't know that, Your Honor.
Thank you.
Justice Sotomayor? Justice Kagan?
I could go back to your example about having high cholesterol and all the various things that a doctor could say. And I don't think, like, anybody wants to remove doctors from, liability or any kind of professional sanction for giving utterly wrong medical advice just because the giving of that advice involves words, right? So if the doctor said you can lower your cholesterol by going out and eating dessert every meal, we would think that was like not a good thing for a doctor to say, and we wouldn't say, oh, the First Amendment has something to do with this. But I guess I have this feeling that that's a different kind of case, that is a case where the speech is incidental to whatever conduct it is that the doctor is offering. whether it's, you should take this pill or you should do these eating practices or so forth and so on. And are you saying that there's no distinction between what we're dealing with here and the range of things that a doctor can tell you in her office about what kind of care is appropriate for any particular condition?
I don't think there's any distinction, because just like in the medical field, counseling is an evidence-based practice that petitioner trained for thousands of hours to be qualified to do. And her advice and counseling therapies, through her words, can be extremely harmful. And so there is no difference between that and the medical context. And I wanted to come back to the first part of your question about calling out a specific practice that violates the standard of care. This is a thing that legislatures do not irregularly. When you have a practice that, although it's ineffective or although it's harmful, it persists anyway. So, for example, in Colorado, there's a specific provision that says it's unprofessional conduct for medical doctors to prescribe anabolic steroids for sports performance. Now, normally something like that might die out, but you can understand why there are cultural pressures that make this continue to be interesting to people, even when they know there's harm. And this has been the problem with conversion therapy. Although every theory that it's relied on has been debunked and debunked and debunked, people continue to seek it and to want it and to believe that they can make this change. And I think that's understandable. It's a challenge to find out that you're a gay or transgender person. And then finally, to the issue of regulating a specific practice, we cited you a couple of cases about this false memory recovery. So there was a practice going on with psychotherapists in the 1990s where they were using a therapy that was causing children to come up with false memories of sexual abuse. And there were several malpractice cases about it. That therapy died out on its own. But if it hadn't, and therapists had continued to do it, and again, it was done only with words, surely a state could step in and say, that's unprofessional conduct. And that's exactly what Colorado and 25 other states have done here.
Thank you.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
What is your best evidence on this record, thinking about the application of strict scrutiny, that this kind of talk therapy by professional licensed therapists to minors causes harm?
Sure. I would direct you, Your Honor, to JA 64 through 74. And I do want to note this particular argument about this specific study came up for the first time at 10th Circuit oral argument. And I think had we had an opportunity, we could absolutely have put in even more evidence to nail this down in the district court. But if you look there, our expert walks through all of the research that's been done since 2009. Aversive practices have not been in use since the 1980s or before, so all of these studies do not concern aversive practices at all. And then I would direct you specifically to the Green study and the Turbin study. The Green study looked at 34,000 13 to 25-year-olds who had gone through conversion therapy, and after controlling for other factors, found there was a 2 times rate of attempted suicides among that group. And in the Turbin study, Dr. Turbin looked at 27,000 participants. This was specifically on gender identity change efforts, including people who had received those efforts under the age of 10. He looked specifically at childhood exposure and found association with adverse mental health outcomes in adulthood, including suicide ideation and attempts. This question about whether it's voluntary or not, that's just not an issue that had ever been raised to focus on. And especially with children under 10, I don't even know how you would assess that. I would also direct you to Dr. Turbin's amicus brief, though, where he further describes the techniques that he used in his study to show how much they would align with, I think, what petitioner would imagine that she would want to try to do. And then you have to put it in the context of people have been trying to do conversion therapy for 100 years with no record of success. There is no study, despite the fact that people tried to advance this practice, that has ever shown that it has any chance of being efficacious. And again, the harm from it comes not from the aversive practice, it comes from telling someone there's something innate about yourself you can change, and then you spend all kinds of time and effort trying to do that, and you fail.
But you bore the burden. She didn't have to show that it was efficacious, right? You had to show that it caused harm.
Right, but in light of 100 years of studies that all point in the same direction with no efficaciousness and evidence of significant risk of harm, we think we amply carried that burden.
Tell me more. You said that in the 10th Circuit, you wished, because if you had been back before the district court, you could have introduced more evidence. Did you not? It was a PI hearing. Why didn't you have the opportunity to introduce all the evidence you wanted to?
There was no hearing. We filed our response in response to petitioner's brief where she had no evidence. We put in a 60-page expert declaration covering all of this, and including not just the studies, but the fact that all of the theories underlying conversion therapy have been debunked. Initially it was homosexuality as a pathology that we need to treat. That's been debunked. Then it was homosexuality is caused by trauma. That's been debunked. Then it was homosexuality is caused by a relationship you have with your parents. That's been debunked.
So just on the very specific evidentiary question, are you representing then that if this went back, you want the opportunity to have a hearing to put in different evidence that it causes harm?
I think if there's some argument that we need to show that these studies were done on people who engaged in voluntary therapy, I think you could potentially go to the study authors and get that. But that particular critique was never raised. And again, I just think if what petitioner is saying is you have to have a randomized controlled trial on children in order to establish with respect to the particular thing that she wants to do, that would be, I think, a study that would, not even medicine would require a study like that to come up with a standard of care.
Justice Jackson?
Can I just quickly get you to address Justice Alito's question about how you distinguish NIFLA? You have definitely focused very clearly on the special relationship, the professional context, and the fact that this is medical care being provided in a counseling relationship. But as Justice Alito points out, we have addressed professional speech and the extent to which it should be treated differently, and it has said no. So how do you distinguish that case?
So professional speech, as it was addressed in NIFLA, is a much broader category than what we're talking about here. It would include things professionals are saying in any professional capacity. We are focused on the very narrow context where a healthcare provider is delivering healthcare to a patient. They are under fiduciary duties to act in that patient's best interest, and they are subject to malpractice liability. And that is just a different category.
So you're saying that this is a very narrow carve-out, no matter what we sort of said otherwise with respect to professional, that you'd be advocating for a very narrow rule here?
Yes, it would be very narrow, and I think it's consistent with the precise doctrines that NIFLA called out as not triggering heightened First Amendment scrutiny, like malpractice, like informed consent, because those are things that are taking place in the exact same relationship that we're talking about here.
Thank you.
Thank you, counsel. Rebuttal, Mr. Campbell.
Thank you, Mr. Chief Justice. On standing, Justice Gorsuch, in response to your question, I heard the state say that they are not disavowing enforcement, particularly if the effort involves discussions that seek change on identity. On pages 216 to 217, Ms. Childs talks about how she wants to have full conversations exploring issues of identity and gender, and that includes considering change. On the issue of studies, there was a reference to the Green and Turbin studies. All of those studies relied on bias sampling, self-reporting. They conflated aversive techniques with voluntary counseling. They did not isolate licensed counselors, and they did not purport, even in their own study, to prove causation. Beyond that, Justice Thomas, in response to one of your questions, the state conceded that it would be speech if it was a life coach, but it's for some reason not protected speech if it is a professional. That is an attempt to revive the professional speech doctrine that this court rejected in NIFLA. This law's viewpoint discrimination is even worse than we've heard so far this morning, because the state of Colorado would allow a 12-year-old without their parents' consent to enter into counseling that would go the opposite way on these issues of gender identity and sexual orientation. But if that same 12-year-old with their parents' consent want to seek counseling in the opposite direction, the kind that my client would provide, they are not able to do that. That kind of viewpoint discrimination must survive strict scrutiny. This law harms gender dysphoric kids because the statistics that we've cited in our verified complaint, as well as in the brief that we cited with this court indicate that 90% of young people who are struggling with gender dysphoria before puberty work their way through it and realign their identity with their sex. But if one of those children go to a counselor and they specifically say that is the help I want, realigning my identity with their sex, they cannot receive that help from someone like my client. Moreover, if they're continuing down the path of transition, then unfortunately they get locked into that path, and eventually it leads over 90% of the time, once they start down the path of social transition, it will lead to the route of medicalized transition, which the CAS report tells us comes with a lot of harm and devastation. And lastly, there should be no remand in this case for all of the reasons that I just explained. In addition to that, I heard Ms. Stevenson say that they were aware below that we were arguing for strict scrutiny and that they had an opportunity to put studies in. So all remand would do in this case is continue to prolong the ongoing harm that's happening not only to my client, but more importantly, the kids who are struggling with gender dysphoria.
Thank you, counsel. The case is submitted. We'll hear argument next in case 245774, Barrett versus United States. Mr. Larson.
Mr. Chief Justice, and may it please the Court. Possessing a gun in violation of 924C1A is a lesser included offense of using it lethally in violation of 924J. The offenses are therefore the same for purposes of double jeopardy, meaning there's a presumption that Congress did not intend two punishments for one fatal shooting. And this presumption controls unless there is a clear indication that Congress wanted to double punish. But there isn't any. As court-appointed amicus acknowledges, 924J says nothing about punishment under both statutes. And as detailed in our briefing, neither does 924C. On the contrary, while 924C is very clear that its punishment applies in addition to that for the underlying felony, it does not say its punishment applies in addition to that for a lethal shooting in violation of 924J. And the reason for this, as Your Honors explained in Laura, is that Congress designed 924J's penalties, which include life in prison and even death, to account for the seriousness of the offense by themselves, without incorporating penalties from subsection C. Indeed, as the Court also noted in Laura, when Congress wrote 924J in 1994, it specifically considered but rejected a proposal to impose multiple punishments for a fatal shooting. Only in 2005 did Congress write 924C5 to cumulatively punish fatal gun use, but only where armor-piercing ammunition is used, and that is not this case. In short, Your Honors, and as 924C5 confirms, Congress knows how to order multiple punishments for a lethal shooting when it wants to. It has not done so here. I welcome the Court's questions.
So are you saying that all of 924C1 is a lesser included offense of 924J?
So not necessarily, Your Honor. If you're referring to things like machine gun use or use of a silencer, we recognize that question isn't presented here. We addressed it in one of our briefs. the scenario of voluntary manslaughter with a machine gun. And we say maybe those are different crimes, maybe they're not.
What about 924?
As to that question, C1D2 is silent. It doesn't address it. And as the Court has explained, silence cannot be a clear indication to double punish.
And
also, Your Honor,
what would be necessary, do you think, to make that clear?
What would be necessary would be something like what appears elsewhere in the statute. We have two examples in 924C of where Congress has ordered multiple punishments. One, it said if you possess a gun, you get a punishment for that in addition to the underlying crime of violence. It's also in C5 said if you use a gun loaded with armor-piercing ammunition to kill, you're getting a lot of punishment.
C5 came in much later. I mean, this was in 71, right? 924 C1D2 came in.
Yes, and even when it came in, Your Honor, in Simpson and Busick, this language was in the statute. And this Court said in Simpson and Busick that this language, requiring a minimum, requiring it to be consecutive, was not sufficient to constitute a clear indication. That's why Congress had to amend the statute to make it crystal clear that it wanted to double punish both possession.
So you want it to be in both 924J and in 924C, the provision that it can can't.
Left side, left side, left side.
Good afternoon, everyone. My name is Jim Campbell. I'm Chief Legal Counsel with Alliance Defending Freedom. It was my honor today to represent Kaylee Childs before the United States Supreme Court. I'm going to let her make a statement, and then I'll come back, say a few words, and answer any questions.
Hi, my name is Kaylee Childs, and I'm a licensed counselor in Colorado. I've spent my career using conversations to help people work through their struggles to achieve their goals. I've worked with clients dealing with trauma, addictions, and struggle with their gender and sexuality. I view my work as an outpouring of my faith. I want what is best for my clients, and often they seek me out because we have a shared faith. When I learned about Colorado's counseling censorship law, I was concerned about its impact that it would have on myself and my clients. Issues of gender and sexuality come up regularly with my clients in our counseling conversations. And Colorado's law would hover over every conversation I have with my minor clients, threatening me with a $5,000 fine, suspension from practice, and losing my counseling license. And while I certainly am worried about my livelihood, Colorado's law hurts kids struggling with gender dysphoria most of all. If counselors wish to engage clients on these issues, the law limits them to one option of encouraging kids to reject their body. That is a tragedy. Struggling kids benefit from access to voluntary counseling conversations that help them as they seek wholeness and gaining peace with their bodies. They deserve better than Colorado's one-size-fits-all approach. Today, my legal team at Alliance Defending Freedom told the Supreme Court that Colorado's law harms kids and censors speech. I'm hopeful that the court will see this clearly and protect free speech for me, for my clients, and for kids everywhere. Thank you.
Today we were able to make arguments before the court challenging Colorado's counseling censorship law. This law is blatantly viewpoint discriminatory. It allows counselors to help a child pursue the path of gender transition, but if a child instead wants to consider getting comfortable with their body and realigning their identity with their sex, this law says they can't talk to a licensed counselor in the state of Colorado. That's unfortunate because it's harming kids every day. There are kids struggling with issues of gender dysphoria, and this law tells them that if they're seeking help in one direction, that licensed mental health professionals and counselors are not available to them. As we made our arguments to the court today, the court seemed very receptive to the points we were making. The court acknowledged that Colorado is trying to censor private conversations between licensed professionals and their clients. Specifically, that would be in violation of what this court said just a handful of years ago in the NIFLA versus Becerra case, where the court recognized the harms of censoring private conversations between counselors, doctors, and their clients. The court gave many indications that it was bothered by the law. It seemed to me that the court views this, at least many members of the court views this as a viewpoint-based law. And under the First Amendment, Colorado is not allowed to censor viewpoints based on which side of the aisle they fall on. With that, I'll take questions. Hearing none? Oh.
What would you say about Justice Kagan? What do you think? Where do you think she may stand on this? She seems to agree with various points made by the ADF.
I do think Justice Kagan was receptive to many of the responses that we gave, but I'm not sure where Justice Kagan will land in the end. Yes.
I'm just curious, what is your response to the critics that say that conversion therapy doesn't work and that it is harmful in the long run?
What Kaylee Childs does is provides voluntary conversations to help minors pursue the goals they've set for themselves. When people talk about things like conversion therapy, they're not talking about the kind of consensual, caring conversations that Ms. Childs provides.
Well, then would she also then help them become comfortable if they decide that they are gay or transgender?
Yeah, she's never been asked to do that, and so that's not a question that she's ever faced.
You mentioned during arguments that Ms. Childs faced several anonymous complaints in the past few weeks. Could you elaborate on that?
Yes, over the course of the last few weeks, there have been numerous anonymous complaints alleging that Kaylee Childs has violated the very law that we're challenging here. And rather than dismiss those complaints, the state of Colorado has sent them to Kaylee and are now demanding that she responds to them. So that just heightens the fact that the state is willing and in fact in the process of exploring the enforcement of this law against Kaylee Childs, and that makes it abundantly clear that we have standing in this case. Thank you.
I hope they're coming.
Good morning. This is Colorado Attorney General Phil Weiser. He'll give a few remarks. We also have members of the legal team coming up and joining. Shannon Stevenson, our Solicitor General. Shannon, everybody come over here, please. You want to stand behind the Attorney General? Okay.
Today the Supreme Court heard arguments in an important case around what is a practice that's harmful, that's banned on a bipartisan basis in Colorado and many other states. It's telling young people that who they are is not okay, leaving lasting harm. This type of pressure, coercion, has been disavowed, discredited by all medical associations. In the United States of America, since the founding, we've had systems to protect patients. There's a fiduciary relationship when a licensed professional subject to malpractice tries to help someone. And it means they need to be doing things that are helpful, not things that are shown to be harmful. The idea that there could be a First Amendment exemption to this is dangerous, can create a lot of mischief. We've made our case to the Supreme Court. We'll now wait on an answer. And if you have a question or two, I'm happy to take one.
Ms. Child's attorney said during oral arguments that there are several anonymous complaints that have been submitted against Ms. Child during the past few weeks. Can you address that?
One of the challenges about this case is the petitioner has put in no evidence into the actual record. If you look at the evidence in the record, it's all put in by the state of Colorado, showing how these practices are harmful. There have been no official proceedings or efforts to take any action against the petitioner. And now, even at the Supreme Court level, they are stating for the first time information that's not in the record, that there's no evidence of, and there's no basis to actually evaluate it. This is not how the Supreme Court should be making decisions. There should be an actual record with facts that have been considered.
Child's team is saying that this is an attempt to censor private conversations. Could you address that and talk about your argument against it?
The long-standing regulation and oversight of medical professionals is treated specially for good reasons. People hold themselves out as professionals who are operating based on a standard of care so the public knows they can trust them. That's very different than private conversations about matters that could be of public or scientific concern. When you're a licensed professional, you have special responsibilities. That's why we have licensing. That's why we have malpractice. This is a very different situation than people sharing their ideas on issues of public concern.
Ms. Child's team said that she's never been asked to affirm a child's gender or sexual orientation. What do you think that says about the kind of services she provides?
I don't know what type of services she provides because we don't have any evidence of what she is exactly doing. And that is a real problem in this case. This has been a little bit of a moving target.
The justices seem to look into the argument about strict scrutiny, and I'm wondering what your reaction to that is and how that would impact the Colorado law in your case.
We will see where the Supreme Court chooses to resolve this case and then how to defend our law. Our job will be to defend our law to the best of our ability, and whatever the court does, we're going to continue to do that. Thank you all very much.
could agree with somebody later. Are you down here?
Sherry, you want to move over to this?
Yes. Sorry, guys.
Next time you'll let the pool. One less thing you have to worry about.
It is. Sorry about that.
I apologize. You've done
Yeah.
nothing wrong, Colorado.
I'd leave it with someone, meet up with somebody later. Yeah, we don't know. How's Lenny? Lenny, this guy, huh?
Who's Lenny? That's yours?
Oh, yeah.
He's not
Lenny, but Lenny made
that. No, I know Lenny made
I don't
that.
get credit for this
I
invention.
know Lenny. I met Lenny. I work with him.
I hear it. John says he's retired.
Yeah, Lenny's
You were
retired.
smarter than us, huh?
Lenny and I worked in Miami together.
Did you?
Yeah.
Leave Davalos.
Leave Davlo.
Ah! Small world.
Small world, brother. I worked with Lee.
Yeah, we talked that last time.
Yeah. You got it. Thank you, sir. Yeah. I'll just use that head before the head wheel. Yes. Yes. Okay. Fingers, Hey, Sarah. Call Lisa. Hey, Sarah. Hey, Sarah.
Oh, he said, hey, Sherry. I'm like, what?
Man.
I'll take that. Hey, Sarah. Call Lisa Lynn. Yes, ma'am. Mm-hmm. And there you go.